I'm praying for file this revisional application with the certified copy and want to move by 7 because by 8 my possession will be taken over in a title.
All right, fine. Mentionings, please come on Monday. Extensions, please hand over the slip. Other mentionings, please come on Monday.
Milord, because Milord, Sonam Bhattacharya is appearing for the other.
Hand over the slip.
Item.
Please come on Monday. Yes.
May I have a lordship's leave to file without the certified copy. File without
What is
this
the urgency?
urgency. The police report has police petition. The petition for help of police has been allowed. 12th is the date where the police will come.
My lord, I'm saying file this revisional application without PM or at any time, lordship.
Why? What is the urgency?
The urgency is that, lordship, the defendant filed the caveat, and due to the filing the caveat, we have served. But due to lack of injunction hearing, the illegal construction is going on, lordship.
File it. It will appear on Friday.
Milord, my junior is there, Milord.
Yes.
I want to file two review application.
Yes.
So your lordship, when the determination of group 1 and my clerk, due to his prolonged illness, the estimate has been left. So that we have
File it. File it. Yes.
leave me kindly be granted for on the basis server copy.
Mr. Datta, for that leave is not necessary. Yes, please file it.
After suffering a decree for eviction, Millard has taken out an application saying that he has filed a suit challenging my Millard ownership in the property, and because of Millard the suit pendency of such kind of a suit, Millard the execution proceeding is halted. Millard the next date is day after tomorrow.
Mr. Banerjee, please mention on Monday because
Millard appearing in the list otherwise.
appearing in the list, upgradation, please come on Monday. Please come on Monday for mentioning upgradation, enlistment. Please come on Monday.
Lordship,
Yes.
only difficult. I do not have mentioned trouble, dear Lordship. The arbitration date is fixed for 11th. If it is no, I'm not on that, Lordship. Only difficult.
Monday.
We are not on that, Lordship. Only if it is heard out on 11th, Lordship, my application for the documents to be brought on record will become infructuous because that day will be the last day. I would not only
Mentioned on Monday.
Lordship,
Why
I
have you not mentioned
on Monday, Lordship? Last day.
You have mentioned on Monday. Please ascertain what is the endorsement in this slip. If you have mentioned on Monday, you need not mention again.
And it is acting harshly upon me. You have taken
Sir, please come on Monday. Yes, call the list.
My lord,
Call the list.
my lord, one humble prayer, my lord. My lord, one mentioning, my lord, one humble prayer. My lord, this civil revision, my lord, was filed challenging the extension of time granted by the learned trial court for
What do
filing
you want,
of
Mr.
arrear date.
Chakraborty?
I want the matter to be heard on Monday at least, my lord.
Yes, please mention on Monday.
Because next date is on
Yes,
12th, my
item number 1. Who is appearing?
My lord, I am for the petition.
Yes.
Mr. Bhattacharya is appearing, my lord.
Since
appearing for the petitioner, my lord, Mr.
yes.
Also, my lord, in the third para, my lord, in the order, name of
What is the correction?
name of the court was wrongly mentioned as junior division. It will be, my lord.
It's senior division.
Yes, it's senior division.
The last bit.
It has been pointed out that Yes,
appear on the behalf of the petitioner.
yes. What is the mistake?
Second para lordships, in the divisional application, my prayer was, your lordship, only to explain the evidence, lordships, not that dispose of the suit, lordship, because connection of the suit, party filed an application for referring the DNA test. That application was rejected, there is a different divisional application. And in the divisional application, and page 10, lordship, order is there, the suit may be proceed, but no final order will be passed without leave of the Honorable High Court.
You have not said that.
I have annexed, lordship, page 10, lordship, I have annexed.
No, page 10 you may have annexed, but at the time of hearing you have not said anything.
My prayer is also only to complete the evidence.
Then you take out an application. That cannot be corrected in this way. Please take out an application.
Lordship, two order will be complete.
I appreciate that, but you have to take out an application. It has been pointed.
And then paying for short passover.
Just start, Lord. In the meantime, Mr. Lairi will come, Lord. He is appearing
Oh,
in
is that
another.
matter? Yes, Mr. Mukherjee, what happened?
Yes, Lord, I tell your Lordship. Lord, your Lordship will kindly have a look into, Lord, I had a talk with Mr. Lairi. Lord, the problem here is, I'll give your Lordship the fundamental problem. But in respect of the entirety of 45 katas, Lord, there is already a registered development agreement with the power of attorney, of which, Lord, the plaintiff has also, Lord, entered into, Lord, in respect of 4.48 katas, which she does have.
Within that 45.
Within that, because, Lord, I have come up with, Lord, the entire shareholding pattern of.
Now what happened?
Now, Lord, they filed, Lord, a suit. This is an absolute speculative suit to contend. Lord, kindly have come to the prayers in the suit, not only for a temporary injunction. At page 34.
32.
34. The prayers are there. Order of injunction so that the in respect of the identical, Lord, the area of land, 4.48. On that score, your Lordship will see, Lord, they have asked for only an order of injunction as a primary relief. It is not, Lord, that I show before your Lordship.
So on that, your contention was that the suit is not maintainable in its present form.
One. Secondly, my Lord, having regard to the principles of the Supreme Court in EC Industries, my client has already
They have to
incurred 20
secure
crores.
or give an undertaking by way of an affidavit. So no transfer, nothing.
Money has to be, my Lord, secured because they have already invested by way of, my Lord, construction in the property pursuant to the registered deed. And, my Lord, there is a RERA registration in respect of the property. Now, my Lord, this two aspect has never been, my Lord, considered by the trial.
And I do one thing. Miscellaneous appeal has been disposed of.
Yes, my Lord.
That's
now
ad
kindly
interim.
come.
That's ad interim.
As against the ad interim order. My Lord,
So I
have
direct the
before
temporary to be disposed of, Mr.
that
Mukherjee.
your Lordship can, but my Lord, kindly allow me, my Lord, to place, my Lord, the misappeal court's order. Because your Lordship will not
Then,
find
Mr.
any ground.
Mukherjee, then I have to fix a date for hearing. should not be at the to be mentioned.
But I'll not take more than 5 minutes, Lord. I'll not take because Lord, my urgency is Lord the
I
construction.
appreciate that. I
stopped.
appreciate
Lord,
that.
Construction has been stopped.
When is the next date fixed before the trial court? I
No,
give you liberty to raise all points there,
Next date কবে আছে বলো? I'll just take instruction.
because otherwise, Mr. Mukherjee, finding this way, that way at the ad interim stage, even though mentioning that without being influenced, it will
But
have some
your
effect
lordship
to either of the parties, which way it will go.
True.
That is why without making that, I give you liberty to raise all things. What is the next date fixed?
27/8.
27/8. So do that. You file a written objection, raise all points.
Let them file a supplementary
Yes, if you want, if you account, have you seen that written objection? Is it comprehensive?
No, Lord, we need to supplement that written objection. Lord, the
Supplement-
points that I take before your lordship, Lord, that is
So
not
you
there.
supplement that
Lordship,
by way of an affidavit.
lordship.
So I give them a short time to give a
Respond.
rejoinder to that, and I direct the all parties are there.
All parties are before your lordship.
No, not here. There.
Yes, yes.
All parties have appeared.
Lord, it is their
Otherwise, they
injunction only against my client, Lord, the defendant number one, who is not the.
all right. So you can be heard in your presence only, even if
Yes,
the others
Lord,
are not
there
served.
3 defendants, Lord, I am the 3 defendants. 2 of my partners and Lord, the partnership.
So you are representing all.
Yes.
So all parties are before the court.
Everybody is before the court.
So
But kindly, one thing. Lord, your lordship will kindly come to Lord the misappeal court's order, which is Lord more damaging to my client because of the fact, Lord, that there has been observations made.
which part of the
Lord, your
observation?
lordship will kindly see, Lord, the portion, Lord, of the misappeal court's
Which
order.
page?
Lord, the judgment. Lord.
Yes, judgment. Which page?
Yes. Now your
Internal
lordship-
page of that judgment.
Lord, 3.6.
3.6.
Lord, that is Lord the,
Yes, 3.6. Yes, I've got.
and thereafter your lordship will kindly see,
No, which observation is troubling you?
my lord, will kindly see, Lord, paragraph 5 of that judgment, Lord. Paragraph 5, internal page 8.
Paragraph 5, internal page 8. Yes.
And then paragraph 5.1, Lord, this is, Lord, what the learned judge has come is absolutely, Lord, contrary to,
let
Lord,
me-
the materials on record.
So you have also challenged the maintainability because there is an arbitration agreement.
Lordship. But this,
Have you filed section 8.5?
no, as of now, we have not filed because, Lord, of the fact that the arbitration agreement is contained in, Lord, the document which according to them is pending registration.
So
So,
it
Lord,
has,
there is no concluded contract in that sense. That's the reason, Lord, we are before.
Well, kindly take the last portion of the order,
yes,
last page, which is at page 11.
yes.
Here the injunction application at the earliest without being influenced by any observation.
No, every order that is there.
I'm
But
clarifying that.
point is,
I'm
Lord, they
clarifying
are
that
trying to-
it will be to both of you.
Both of us.
Yes.
It
Uh,
is. And Lord, the difficulty here is that, Lord, they are trying to unduly enrich themselves by claiming, Lord,
No,
Lord,
I
the
say- I
equal
say
shares
that
of the profit.
This application under Article All right, please give it to me, Mr. Mukherjee, you can, yes.
Well known judgment.
কি বললাম?
Junction suit simplicity.
I'm
Other
coming to
one
that.
is blood about blood, the maintainability has to be looked into. And blood, there's another judgment, your lordship knows 95 CWN 1022, blood, there's no injunction in a non-maintainable suit.
Though this matter
I'm grateful to you.
Yes, call the next matter. Yes,
This is that matter which was taken up on Saturday.
DRT in one state, DRAT in another state. Yes,
Squarely covered by your Lordship's judgment of NCDEX E-Markets Limited. Lordship may kindly record it and
all right. Please give me the judgment. Oh, that was also in Hyderabad. You are also in Hyderabad.
DRT to Hyderabad, that was 85 days delay minus 194 days delay.
I told you because that's also on condonation of delay.
Had I come across this judgment before, I wouldn't have filed it here.
The petitioner
Appearing for the petition.
Petitioner? Yes.
But this is an application for reimposition of, this is an application for reimposition of the interim order, my lord.
What is the impugned order?
My lord, impugned order, my lord, the addition of party in a demolition appeal has been rejected.
Has been?
Rejected. Against that I have come up. I am the complainant.
Yes, complainant is a
Lord-
necessary party, Mr. Bhattabhatha.
That is my, very short matter, my lord.
The actual fact is on the instant of the petitioner, my lord, the proceeding was initiated, my lord.
Then who is, you are the private party?
I am for the,
Yes, the complainant is not a necessary party.
my lord, your lordship kindly see, my lord, practically against the order of the, against the order of the municipality, my lord, we preferred that appeal.
Maybe.
Now, my lord, he is neither a necessary party nor
Yes,
a
yes,
proper
yes.
party. My lord,
Complainant is a necessary party.
practically, I have to satisfy whether I have raised any illegal construction or not before the appellate authority. So, my lord, unnecessary, why he should be part. My lord, your lordship kindly see the impugned order.
Yes, yes.
My lord, kindly see the impugned order, my lord. My lord, last observation
Touching
by
my entire boundary wall, my floor, my window, the construction was made. I am, my lord, seriously affected. For that, my lord, I made a complaint.
last part of the order, my lord, your lordship kindly see, my lord.
What is that you want to hide from the tribunal? Let him, it's better if he appears, he can raise all points, you can meet all those points before the tribunal.
My lord, unnecessary, my lord.
Not unnecessarily. You want expeditious. I am directing
Yes,
the
yes, I-
tribunal to dispose of expeditiously within 4 weeks.
My lord.
No, no, my lord.
I will not permit him to delay. I will not permit him to delay. I will direct the tribunal to dispose of the appeal within 4 weeks. That will serve your purpose. You don't want that. Thank you. Ashun, though this matter
My lord,
I'm seeking, my lord, extension of interim order of stay, my lord. Still order was passed, my lord, on 2nd January 26, my lord, by my lord Sompa Sarkar, my lord. Thereafter, my lord, it was extended. Have you served? Yes, my lord. Already served. Affidavit on service already on record, my lord. Last occasion on, my lord. When the interim order expired? 31st July, my lord. None.
Petitioner, my lord.
Yes, what is the application for?
Mr. Bhattacharya is appearing on behalf of the opposite party.
Order 26, Rule 9, my lord.
Since I'm not inclined. Yes.
Order already, my lord, extended by coordinate bench, my lord, for this month only.
Interim order already extended till
This month, my lord.
till August.
Yes, my lord.
Then why have you mentioned for extension?
Not mentioned, already it was appeared, my lord. But kind of
Uh,
keep the date for contested application so that matter can be heard with merit, my lord.
It has been. Yes. Extension.
Extension, Lord, it was extended last time, Lord, on 2nd of February.
Who is opposing you?
Lord, none had appeared, Lord, as I find. The last order was 23rd
What is this?
of
What is the impugned order?
Lord, Order 7, Rule 11, Lord, rejected. I am the defendant in a suit, Lord, wherein they have prayed for a declaration that, Lord, my invocation of, Lord, the checks, Lord, the putting the checks, Lord, before the bank for encashment is illegal. Lord, I have contended, Lord, it is in contravention of Section 141 and 142 of the Negotiable Instruments Act. The suit was not maintainable.
Plaintiff, I think, is not interested.
Plaintiff, Lord,
Yes, you are the defendant.
I am the defendant.
So plaintiff is not interested, perhaps,
I do not know,
because the
Lord,
suit has been stayed.
the suit has been stayed.
This is the application you have paid for extension. By this application,
Lord.
it has been served.
Yes.
Extension application has been served. Have you filed the affidavit of service?
কোথায় দিলি সার্ভিস হয়েছে দেখেছিস তো দেখেছিস তো হ্যান্ড করেছিস
Can 2 of 2026. যেগুলো ক্যান ছিল ক্যান ডিসপোজ অফ
Interim order has been expired on 16th of July, Lordship.
Yes, have you filed any application? Then cannot be extended.
Takes up next week. Next week, my lord.
Why?
Because the service is not yet been completed also.
You have not served.
No, sent. The preemption, my lord, partial preemption. I can satisfy your lordship, my lord. Here and now.
The Mr. Royal Honored Advocate appearing for the
My lord, I am for petitioner. My lord, the
Yes,
opposite
Mr. Mahato.
copies have been served upon the opposite parties. My lord, delivery report is there.
What is the impugned order?
My lord, by the impugned order, my lord, the suit has been directed to be proceeded with ex parte. My lord, as I have not, my lord, filed the document in connection with my evidence. My lord,
Now
initially,
suit has been stayed
yes.
by the interim order.
By the impugned, by the order dated, it is at page 9, my lord, by order dated 12th of December. My lord, it is stated that at the middle, defendant did not comply order 13, rule 1 of CPC in view of the order dated such and such. Suit shall proceed ex parte against him for non-compliance. My lord, I filed an application for acceptance of my so cause, and my lord, for to take it up from the ex parte, to vacate the order for ex parte hearing. My lord, that application has been, my lord, rejected.
The affidavit, you have filed the affidavit service,
My lord, affidavit service I prepared, but in the morning I could not send it for.
but it has been served.
Yes, yes, yes.
Mr. Mahato,
File it by today. After
Mr. Mahato, Honored Advocate.
My lord,
Yes.
for the petitioner, Mr. Ghosh is leading me. He is out of station, but your lord, if your lordship want, my lord, I am placing this.
Yes, yes.
And in this matter, my lord,
What order you are challenging?
challenging the order number 22 of dated 15 June 2026, my lord. There, my lord, the learned court has made some adverse report against me, against the local investigation was conducted.
Order dated?
Order dated 15th June, my lord.
Yes, what adverse remote? Inform Learned Advocate Commissioner to conduct local investigation as per order dated.
15 of
If the pleadings is not submitted by the defendant, supply the same at once to, so you supply the, have you supplied the pleadings?
thereafter, I'm placing this matter, my lord. After passing of this local investigation order of local investigation, my lord, the 2 dates were given, which was the actually court was open on that day. Thereafter, my lord, I have written a letter to them that the advocate commissioner kindly have a look into page 45 of my application.
Now you have the copy. How soon can you serve the copy of the pleadings?
Pleading, my lord, how can I, my lord? That was already done. And my lord, kindly have a look into the
No, what was already done?
local investigation done, my lord.
Local investigation completed.
Report
When?
was submitted. Yes, my lord, in this order it has been written. 22.
No. Local investigation Commissioner was only appointed on 26/11/2025.
2025, thereafter 4 dates given. 2
Oh.
dates, my lord, I objected because court was open on the 2 days.
Record commission report has not revealed from the record. The commission report has not been.
That has been submitted, my lord, in the meantime.
That has been submitted.
Well, will you have a look into page 45?
No, 18th of August 2026 for awaiting commissioner's report.
That has been given, my lord, in the meantime. That has been given.
What is there? Now the commission has been, what you will do with that observation?
Kindly have a look into, my lord, 2 dates, my lord. He has not seen. I have made one application for recalling of commission.
Yes, not?
2 dates, my lord, given on those 2 dates, 8/5/2026 and 15/5/2002, court was open. And I have written a letter to the commission that kindly change these 2 dates. After that, when I was appeared, my lord, on that day, look, the advocate commissioner said that your application was rejected. In spite of that, the order, both the parties' application was allowed. But kindly have a look into page 48 and 45.
Yes, your application was also allowed. Yes, then what is the difficulty?
So, fixed point.
Then let the report be filed first, then you will be entitled to raise all objections.
I have written the,
I give you liberty, madam, to raise all objections when the report is filed.
given the application for recalling the writ.
Oh, the commission has already been held now. Now, how can the writ be recalled? Now, if you have any objection against the report, file your written objection against the report.
My lord, fix it after Friday, my lord, because Mr. Ghosh will come and.
When Mr. Ghosh will come?
Friday. Friday.
My lord, I am for the petitioner, my lord. I'm starting, my lord. Then expeditious disposal of the 151 application, my lord, where
151 is for what?
my lord, 151, my lord, probate case has been dismissed, my lord. Has been dismissed on the ground that I have not added the party. I have not.
This case is dismissed for default.
My lord, it is for dismissed, my lord. Probate
This case is dismissed for default. Then what expeditious you are want?
My lord, I have already filed 151, my lord, for recalling of the order, my lord.
When have you filed?
My lord, already, my lord, filed on 18 dated. On time, my lord, I have filed, my lord.
When? Now the miscase has been disposed of. What remains?
Not disposed of, my lord. There is a difficulty.
See, dismissed for default. 18th of March, last order.
Then, my lord, I am praying for short Passover, my lord. I need, my lord, Mr. Devji because he's
This application under order, please approach the district delegate for fixing a date.
I approach 3 times. Kindly give us specific direction, my lord. I will approach for
If such an approach is Mr. Mukherjee, I cannot say that. Let him. I've said in accordance with law. I've said. Yes, I've said in accordance with law. Yes. Yes.
At this what?
Yes. Next.
Within 7 days, within 3 days, I will say. And within 3 days,
Within 24 hours. বলে তো লিখবেন না ওটা।
I will do that.
Yes. Next.
My 16, I'm appealing for the petitioner, my lord. But this matter, my lord, wherein, my lord, revision directed as an order, but only 7-1 application has been allowed, directing the defendant to deposit the rent from current month, and my lord, this application has been allowed after a year, total beyond the stipulations.
You are the plaintiff. I'm staying the suit till the disposal of the civil division application.
Well, I'll come back and so, my lord, lordship will take so.
Contested application, let it be heard in 2028.
Lordship will, my lord, give me, I'll serve back, my lord, lordship will keep it on next week, man.
This application under Article 220. Yes, how this help you?
So help in respect, in 7-2 also he has admitted that 600 rent is it's an admitted rent. In 7-1 also it's an
How this
admitted rent.
judgment helps you?
Helps
This application was filed belatedly.
belatedly.
And here application was filed within time.
Within time, I want the direct the 7-3 will be applied.
What prevented the court from passing an order on that date itself?
That is, they have taken time. Lordship, I have annexed the time.
Who has taken time?
Lordship will kindly seize.
Who has taken time?
Lordship will kindly see, my lord.
Yes.
My lord, I have annexed the certified copy. Lordship will kindly
Yes.
take, my lord. My lord, second order number 2, my lord. They appeared. After that, my lord, order number 3. Lordship will kindly seize, my lord, supported by affidavit of determination. This was filed on 1st July 2025. This 7-1 application.
Yes. So when this period end?
My lord, they have filed the application within time.
That is what I am telling you. So what was the prayer there?
The prayer, Lordship will kindly see
So
7-1.
1st of July. So
Yes.
that was within 30 days.
Yes. No,
So what prevented the court from allowing that application on that date
Lordship
itself?
will kindly see the application once. I'll just show you the application once. Lordship will kindly comes to page 26. Lordship will kindly see once. This application itself is also
The court fixed a date for to give you time to file written objection.
7-1 application, Lordship will kindly seize. 7-1 application.
Yes,
Lordship will kindly see page 26.
yes. Yes.
And to submit instant seeking permission of your honor for depositing current monthly rent in respect of the suit premises for month of June 2025.
Yes.
So ADR was not paid by him also. ADR there is a due and in the 7-2 he has admitted the 600 rent, there is no disputing.
Yes.
There is an ADR of 36 months that is specifically he has stated in 7-2 at page 28 paragraph 2. He should have come with that application along with the arrears of rent and the current month.
That is 7-2.
7-2. What is the difference? There is no difference because he is not disputing the rate of rent. He has only asked for installment. Lordship will kindly seize the abaments statements he has made in the application. It's not that he is disputing the rent. He is admitting that 600 rupees rent. In 7-1 also, even my return statement also they admitted 600 rupees of rent. But he is seeking installments in 7-2 and in 7-1.
Where is your plaint?
Yes, madam. Plaint at page. It starts from page 15, my lord. Lordship will kindly takes at page 16, paragraph 3, third line, my lord. I have said 600 rupees rent.
Page?
Page 16, my lord. Internal page 3 of the plaint, my lord. Paragraph 3, third line. 600 rupees rent, I have said also.
And area since?
Area since, I have said. He has admitted.
January 15.
Yes, madam.
Your allegation is January 15.
Yes. And they have specifically admitted for 36 installments. That is their specific case.
And they have not deposited anything along with this application under section 7.
Nothing. That is my case, ma'am. The facts are this. मतलब सर्व एंड कम मतलब
স্যার সার্ভিস ডিসিশনটা দিয়ে নি Yes, call the next
it
matter.
can be मतलब it can be hard मतलब
Yes, yes, yes. Many points are there, Mr. Huh?
And in execution proceeding for
Yes.
execution of a money decree, I filed an application under Order 21, Rule 5859, because my property was attached. Now, the learned court held that the transfer by the judgment dated to me was fraudulent.
That's an appellable order.
No, madam. This Order 21, Rule 5859 is not available.
Not an appellable order. Are you sure? CPC টা দিন। Have you checked up?
Yes, I am checking, madam. Rule 72,
Please see Order 21, Rule 58, Sub Rule 4. Yes.
So the proceedings under the Maintenance and Welfare of Parents Act can be initiated against subsequent purchasers for the purpose of providing alimony under Section 23. I am the subsequent purchaser for value proceedings initiated. It was held that there is absolute transfer. Now, my lord, and proceedings has been initiated
No, there was a gift deed
in favor of the son.
in favor of the who are you?
I am the subsequent purchasers for the son.
So the senior citizen executed a gift deed in favor of the son,
Yes.
and you are the purchaser from the son.
Proceedings initiated against me.
Proceeding initiated against you.
Similarly,
Or
under the Senate for providing maintenance.
for providing maintenance.
This is the notice. I am challenging the notice. 132. Being the children, from where it is.
Mr. Rai, you could have appeared on that day.
Appeared, said we are not in a position to do anything. That is, it appeared, but kept in abeyance. Previously, my lord,
Where kept in abeyance?
this notice I appeared on that date. It was
Yes.
brought to the notice. Did not take any steps, just keep it. Because kindly turn to page 131.
131.
Once.
Do you have the Senior Citizen Act?
Yes.
এখানে আছে Senior Citizen Act? Senior Citizen Act আছে?
That is page 114.
Mr. Rai, your status has
114.
been elevated.
114.
You become a son of that senior citizen.
114. Can I turn to
You
the
have taken his property.
114 of this revision application? Can you turn to 114?
You will take his property, not maintain. Two things cannot go side by side, Mr. Rai. You take his property, you
Filed a suit. Suit dismissed. Default. Did not take any steps, be as it may. Proceedings initiated. Did cancel challenging that I before this honorable court. This honorable court category held there is no such clause. Apart from that, he have filed a suit. And Manan Kali consider
who is the opposite party number one? He is the
opposite
he is
party.
the opposite. Who is the opposite party number one?
Anjali Wala Ghosh is the mother, senior citizen.
No, she has lost the complaint.
She has lodged the complaint.
So the property was of the of Anjali Bose.
Yes.
Who is
It
the
was
opposite party number two?
Son, though he has not made party, my lord.
Bose's son is Ghosh.
Ghosh.
What are you saying? Son of Bose is Ghosh.
Ghosh, my lord. It should be Ghosh, my lord. It is my type of agreement.
So no. Husband's name is also Bose.
It should be Ghosh.
So husband's name is also wrong.
No, type of G. It should be G.
What are you doing, Mr. Rai? একদম উপরে একটা লিফট দিয়ে দিন, না হলে ওই সেই আবার
One.
131, yes.
This proceedings initiated under the same act pending. Challenging that I am before this honorable court and same is appearing before your lordship as item number 1226. So it is a repeated application filed, proceedings initiated.
So,
During the pendency of these proceedings,
Mr. Rai, what have you done?
Here.
Page 131 is the subsequent notice.
1/9/2025.
Oh, 2025.
Yes, my lord. Same proceedings.
This is pending.
This is pending. Press memo, press proceedings initiated.
Ashun.
Can be taken up along with that. There is no caveat. 1226. This is
Oh, that has not been moved once.
no.
Ashun, what is the item number?
1226.
1226 টা বাদ করিয়ে দিন. Do you have a copy of that?
Same, my lord, only this.
This notice.
This notice, the earlier notice. 131.
Do you have the CO number?
Yes. Yes.
Mr. Rai, learned advocate, appearing for the petition দুটোই একসঙ্গে।
Would be hard analogously, my lord, otherwise.
I've said taking up for analogous hearing. Today I have taken up for analogous hearing. Anything remains, Mr. Rai? Yes. You are busy. Something is playing in other courts. That is why.
One is taking cordial side, so we are.
Yes, next.
I'm for the opposite party number 13 and 14. Opposite party, caveator opposite party number 13.
Deviator opposite party. Please use the microphone. Yes, Mr. Das. Please adjust the microphone.
I'm for the petition.
Adjust the microphone. Yes.
Here the instant case knowledge is against a rejection of an application under Order 26 Rule 9. But my case is my learned friend's client. Previously there was a history. But
Previously there was.
Previously my learned friend's client filed an application, writ application before the concerned authority. But that application was not disposed of on the ground that I am raising illegal construction on the pond. Matter was referred to the this order was challenged before the Honorable Division Bench. Honorable Division Bench did not go to the merits of the case, but directed the concerned municipal authority to decide the matter. The municipal authority, my lord, after hearing both sides, my lord, there was an inquiry from the BLRO. It found that there are construction on the plot number 100, which is the Pukur.
Plot number 100.
This is Pukur.
All right.
My case is that
plot number 100 is a Pukur.
Pond.
Yes.
But
you are making construction on pond.
No, I am.
You have said that
the authority found. BLRO found.
BLRO found. All right.
But then what happens? My case is that I have purchased the bank of this pond, and I have raised construction. My father raised construction. I am living there.
What is the plot number of the bank of the pond?
100.
100.
On the bank, Pukur Par. I have purchased Pukur Par.
All right. So according to you, you have not constructed on the water body, but you have constructed on the bank of the water body.
But accordingly, I filed an application for local investigation before the learned court below.
What is the suit for?
Suit is, my lord, not suit. The Board of Municipal Authority passed the order of demolition under section 218 of the Bengal Municipal Act. That was challenged before the court in accordance with law. Therefore, appeal case.
So in an appeal under section 218 subsection 3.
My lord, of the
Bengal. So there you file an application under Order 26 Rule 9.
That application was rejected.
To ascertain what?
Show
me the application under Order 26
my
Rule
lord,
9.
Kindly see page 30. Investigation Commissioner is conduct survey and relay the plot number 100 and to ascertain the existing construction of the appellant is
number 13.
30.
Oh, 30.
And to ascertain the existing construction of the appellant is falling within the water body or not. Investigation Commissioner is to ascertain the measurement of construction of the appellant which is falling within the water body, if any. Investigation Commissioner is to draw and submit a sketch map according to scale showing the existing position of the construction. PLRO, my lord, has not made any investigation. He has simply.
Where is the order of demolition? Please show me.
My lord, I have annexed.
Because that is under challenge in the appeal under 20. Yes, please show me the order of demolition.
Page 14.
Page 14. My lord, the relevant portion you lordship will see page 16.
15.
Please give me a minute.
Today at the time.
Please give me a minute.
Investigation Commission was not done. He has simply filed a report. The petitioner before my lord.
Where is the sanction plan?
under the scheme, Pradhan Mantri Awas Yojana. And your lordship will create it, my lord. Kindly see page 20. Page 20. That
20.
Page 20 of this revisional application. Para 5. That your appellant states that your appellant's Raju Manna's father, Madan Manna,
All right, please give me a minute. What is the impugned order? Please show me.
It was only on the ground of delay, it was rejected.
Only on the ground of
Delay.
delay.
Delay. If their investigation is done, then there will be a delay. That is the reason. Ultimate finding.
Mr. Das, when the this report was filed by the BLRO, field verification was made. You are present there.
Yes. That report has been
Where
carrying the
a
appeal.
report was supplied to you.
Yes. Yes.
So you
Not-
did not raise any objection at that point of time.
Yes, I have raised objection. In memo of appeal, these order
No. When the inspection was being made in the
order
report,
was passed, inspection was made, order was
in your presence,
yes, order was passed, and that order itself challenged. Can you see my memo? I have annexed. I have challenged the report of the BLRO in my memo of appeal because the entire thing is under adjudication of this appeal under section 218(3). And my lord, BLRO has not made any commissions. A survey commission is required. And kindly see the points for local investigation. I have not prayed anything, only to ascertain whether my water body, that construction is within the water body or not. Kindly see page 24. This is my grounds itself. That is to be considered. Page 24, last para. I have specifically taken ground, objecting to the report of the BLRO. (24, 25). BLRO has not made any manner investigation. And when the matter is sub judice,
yes, Mr. Ghosh, you are appearing for whom?
I am for the opposite party number 13 and 14.
Opposite party number 13. Who are they?
We are the adjacent plot holder, my lord. We raised
You made a complaint.
complaint on.
So you are the writ petitioner.
Yes, kindly
All
come.
right. So
Kindly comes to the order passed by the honorable division bench. Admittedly.
you are brothers.
No. I am the co-sharer of the pond.
Yes.
Admittedly, the construction, first kindly comes to the impugned order, last, the second page last. If they did not make any construction on the plot number 100, why they prayed for the conversion of that? What is the necessity? That was recorded in the impugned order. Admittedly, construction.
You have a copy of the report. Where you supplied with the copy of the report.
That is
only one thing. Because here in this impugned order, it also says it prima facie appears. LR plot number, because LR plot number 100. So its part is the pond, part is the.
What happened, my lord? Before the writ court, what they did, they made a pillar in the water body by encroaching the water.
So for
and
that
made
it's better
construction.
that a local investigation is held.
No, now
where is the report?
I shall kindly fix the subsequent date. I shall produce all these things. Admittedly, the construction is plot number 100. My learned friend is saying these are under the scheme. Under the scheme,
Sanction is not
not
required.
required, but the government plan is not that he can make construction in the
The
water
water
body.
body is not permissible.
That is the submission before the honorable single bench in the Reef Court also. Now on the and the division bench also that submission was made on their behalf.
But on the bank of a water body, Mr. Das, can you make a construction?
No, that cannot.
I purchased the same.
No, that cannot.
You have purchased, use
That-
it as a bank of a
But
pond.
for that-
Please show me that you can convert the bank of a pond for the purpose of construction. Please show me. Please show me the law. Then the entire purpose of that bank is frustrated. Why a bank is there of a pond, water body, to access the water body?
Now the government circular is there. If somebody
Cannot make a construction on a bank also.
Purchased the same.
Maybe,
Father is-
Mr. Das, you may have purchased, use it as a bank, but you cannot construct on that.
Already, this bank, my lord,
Cannot-
already construction was there. Kindly
Maybe,
see, kindly-
Mr. Das, if it is illegal, it can be removed.
but
Even if it was there, it can be removed.
but kindly see one thing. Kindly see,
Please show me that whether construction on the bank of a pond is permissible or not.
in the deed itself, my lord, there was mention that their house is there.
Mr. Das,
But
you are not,
after-
you are refusing to understand.
I understood, my lord.
Maybe
Can
I
I
appreciate that there was a construction, but if it is illegal, it cannot be removed.
Illegal in the pond, if it is appearing in the.
That is what I am asking you. Please show me that construction on the bank of the pond is permissible. Under which provision? Please show me.
Then I will have to file my deed, patent deed, my lord.
Not deed. Deed, I accept your submission that you have purchased the bank of the pond and there was deed.
Well, for the order of the PLO, your lordship. will cite
Mr.
and
Ghosh,
others.
please bring the copy of the report, because if the demarcation has not been properly done by following that procedures, then an investigation has to be done. Because the exact identification that has to be done.
yes, the revenue authority is the competent authority for the land, the classification of the land.
Maybe, but how this was done, please bring
Alright,
that report.
alright, sir.
Because if that report was not, or the investigation was not conducted in your presence, report not supplied, then what can be done on this?
All these, throughout all proceedings, they appeared and they participated all these things.
Yes, when can you produce?
The next week, I have to.
Mr. Ghosh heard Mr. Das Both the prayers cannot be accepted,
yes,
Mr. Das.
I have not heard much.
I'm
Yes.
for the petitioner, your lordship.
Yes, what do you want?
I'm for the petitioner.
Yes, what do you want?
The impugn order at page 38, your lordship.
Yes, what is your prayer? Expeditious hearing.
Expeditious.
Say so.
Other prayer, your lordship, for setting aside the order dated 12 June 2026, Lord.
What is wrong in that order?
Lordship, that time has been allowed to the defendant without any prayer of adjournment, and the statutory period for filing the written statement has been elapsed, your lordship.
Then it cannot be expedited, madam. I can entertain that. Then I have to stay this. Suit will get delayed. Choice is yours.
Lordship will first.
What do you want?
Expeditious disposal.
After some argument, the learned
For the petitioner, this is my application for expeditious disposal. May I
Of
just
what?
give the, my lord, applications?
What are the applications?
Application one, my lord, this is my suit for eviction, pending since 2019. Tenants have not paid one farthing since
Order 7,
2005.
Rule 11, Section 7(2).
Yes, my lord. And
Any other application is there?
they have also filed, the defendants have also filed an injunction application. They have
Injunction.
prayed for rejection of my plaint.
Injunction application is fixed for hearing when?
No, my lord, the learned trial court has fixed the Order 7, Rule 11 to be heard. It was filed in 2023, my lord, August. It was filed in.
This application under Article 227 of the Constitution of India.
Application as well, my lord, it is pending.
Let 7(2), if it is allowed, your suit goes. Then 7(2) may not be necessary.
But my
Yes,
suit
next,
start-
next.
I
Yes.
am the petitioner preemptive, my lord. Against in preemption application, my learned friend's client got the injunction not to change the.
Aviator.
Yes, yes. And
Yes.
my lord, thereafter I file an application on 151 to cultivate the land. That has been rejected. Against that order, I have come. My lord, kindly come.
What is the nature of the land?
A cultivable land. My lord, kindly see the order.
Sir,
once.
Mahato, let him cultivate.
No. Why?
Why?
Well, what is his abutment? What is the abutments in the made application? He is not cultivating the land.
Then
Another Borgather is there.
No. My father, not
Yes,
the
maybe father, but he is a Borgather.
Once
Status
upon a
is different.
time, he was a
the
Borgata.
Borgada's cultivation.
In that event, daughter of the Borgata has no right, my lord, to cultivate the land.
I purchased the land. Subsequently, I purchased the land.
Being an owner,
Huh,
unless
yes.
the my lord, preemption application is decided, he should not be allowed.
Who are you? Co-sharer?
Yes.
You are lucky that the Borgadar has not come.
Yes.
If the Borgadar has come, then you
The
will
matter
not
will
have any right of under Section 8, Mr.
Compromise is
You will have a
going on.
preferential right over you.
When a talk of compromise is going on, most probably the preemption application will be solved. Some money has been handed over.
Because he has a preferential right over you.
Yes, that's true. I am not opposing. But my lord, here the application is not made by the Borgadar. And Borgadar has no right to make application here.
My lord.
In the preemption application. For enforcement of Borgadar's rights, the forum is different.
My lord, the question of Borgata does not arise because, my lord, my father.
Thing is,
But I am cultivating the land.
No.
Why she will be permitted? He has a stranger person.
how can you cultivate?
How can he?
My lord, through my,
No preemption application has been allowed.
I am the co-sharer. My lord, he has purchased the land. Well, which portion his, which portion mine, that has not been.
So both of you are cultivating. So jointly you cultivate.
Well, since-
How can an order of injunction be passed in this way then?
Well, they
Over
have
an
not challenged that order. Well,
undemarcated
they have
plot.
not challenged that order of injunction.
Mala kindly see the impugned order.
In a preemption proceedings in 227 that can be taken up. Not an appellable order. There's a
Well,
decision.
they have not challenged that.
This before this order is both extension of ad interim order of injunction is also there. And this certified copy is there.
That's
Suo
true,
motu
but-
power under 227 is also there.
But they have not.
Everything is there.
Since my lord is there, I am saying that, but they have not taken that point. Their only grievance is
Now they will be taking
But
that.
one, but 151 application has been rejected without assigning any reason. That is his grievance. Only one line, 151 application is rejected. But I should not support that. Kindly remand it back to the trial court.
Mala kindly see the my prayer, my dharana.
Mr. has understood the pulse of the court, then he has considered that demand is
That's why.
Ashun. Yes, the
Has been allowed that the holding only
what is the suit for?
eviction.
Please use the microphone.
Eviction, Lordship.
Eviction.
Eviction.
Whose evidence has been allowed under Order 18 Rule 16?
Sister of the plaintiff.
How is evidence is relevant in a suit for eviction?
I do not know. That point we have taken. That point we have taken in our objection also.
Oh, you are opposing that application?
Yes, yes.
Now, wife and the constituted attorney of the plaintiff, first evidence was allowed. They challenging that order, file a revisional application that is pending, Lordship. Subsequently, another application filed for depose the sister of the plaintiff.
How that evidence of the sister is relevant in a suit for eviction under the West Bengal Premises Tenancy Act?
That point we have taken, and Lordship will kindly come to the impugned order last paragraph.
Yes. But the wife of the petitioner, Lordship plaintiff, is a constituted
That's
attorney.
neither here nor there. That civil division application is pending.
Yes.
For that, the sister will come.
That is the reason that has been quoted. That civil division is pending. She is of old age. Considering the matter of a civil division.
What do you say?
80. And I have a judgment of the Supreme Court which has categorically stated age is not a matter where this I have a judgment of the Supreme Court.
On what point?
This point only. Order 18, Rule 16. Only age and ailment is not enough. Ailment should be that that type of ailment which will cause.
How this person is a relevant witness?
Regarding sister, may not be.
Sister, family member.
No, she's not.
Then
one time they are in residing in that place.
It's the duty of the landlord to prove. Maybe wife may come, sons may come. How the sister will come?
Sister may not be.
You want to consider this and come back?
Yes, Lordship.
No, your Lordship will kindly
Lordship.
consider this judgment.
Because-
Lordship, once this judgment, the point. Kindly see the last paragraph of the order. The
I will
point
consider
which
because,
has been
because
allowed.
Lordship, whether this inherited property or not, that should be considered, Lordship. I will take necessary
Last
instruction.
paragraph.
If there is a
All right,
parental
I'm
property,
funding this because no reasons has been assigned here. Only on that ground. it
I have
cannot-
paragraph 36 left. I have put a pencil mark. Paragraph 36.
36 or 35?
36, 37. I have put a pencil mark over there.
it should be ascertained whether it is a parental property or not. That should be
The
considered.
applicant should adapt it rather, starting from that.
This facts, Mr. Rai, is the difference
Let me
because
the fact.
there they took out an application prior to the commencement of trial. So that reasoning is there, but here it's one thing.
So no reasoning is being, let it be remanded back, let it be reconsidered, Lordship.
It will be also be ascertained, Lordship, whether it is a parental property or not. If the parental property, then the sister can depose the Lordship. Kindly ascertain.
Property.
I will ascertain. Lordship. Kindly take up in the Monday.
I'm remanding to
Then the my respective submission will let the suit may be disposed of expeditiously because the eviction suit, Lordship, pending, both are the senior citizens.
your evidence. Please don't pray for expeditious at this point of time.
They are
Then this witness will not be allowed. That is pending.
This witness has
Will
started
be
and-
difficulty. Please consider this in all matters mechanically. Don't pray for expeditious hearing. This application under Article 220.
application on behalf of the defendant. This is a suit filed by plaintiff being one of the owner of an association, challenging a decision taken in the special general meeting by the association for enhancement of the maintenance charges.
Who are the learned advocates appearing before the
Lordship,
trial court?
learned advocates.
Appearing before the trial court.
I'm not aware. That, Your Lordship, they are really
Your
not aware.
counterpart, your other side, please ascertain. I'm making it not today. Yes, next. Not today, next.
But I for the petitioner. I'm praying for expeditious disposal of my suit filed under my specific performance of contract. Out of my 26 lakhs of consideration amount, I have already paid 20 lakhs, but the property has not been registered.
Who are the learned advocates appearing before the trial court?
That I have to ascertain.
Please ascertain. Not today, next.
And the plaintiff in person.
Yes.
Plaintiff in person, my lord.
Praying for?
Plaintiff in person.
Yes, what do you want?
My lord, the impugned order is specifically written for your lordship supervision.
This is the order under challenge, 2nd of July.
My lord, two petitions were under consideration. One substitution petition filed by the plaintiff and one strikeout petition filed by the defendants. There is no objection regarding the substitution petition. Under the strikeout petition, my lord, two influential necessary parties have been struck out for which this revision application is filed.
Two?
Influential necessary parties, my lord.
Yes.
Defendant number 6 and 12. Here, respondent number 1 and 2.
Where is the plaint?
Plain, my lord, first annexure, page number 14.
12, 6 and
6 and 12, my lord.
they have been struck up from the array of parties.
Yes, my lord. And on 21st.
What is the, please show me from the plaint the allegation against defendant number 6 and 12.
My lord, several causes of actions are there. Several causes of action.
Please show me from the plaint pleadings.
May I refer to the written objections? Directly it is written there.
From the plaint, you have to stand on your own plaint.
Paragraph number 29.
Paragraph number?
29. Plain.
29, plaint.
Page number 22. Where defendant number 6 along with the father bought another entire house having title dispute nearby. One of the several causes.
What is the suit for?
For declaration and injunction.
Declaration of deed of conveyance.
My lord, three things are under challenge. And these defendants are all related to each other, are local in nature, and are most of.
What is the relation between you and the defendant number 6?
My lord, defendant number 6 is the daughter of the purchaser of the second number of deed. And purchaser.
How she is a necessary party in this suit?
My lord, they formed several companies.
Madam, you have challenged certain deeds of conveyance.
Yes.
Is the defendant number 6 a party to those deeds of conveyance?
My lord, her mother is party, but she is not a party to the suit.
So if she is not a party, how she is a necessary party in this suit?
Then, my lord, her mother should be a necessary party.
That's neither here nor there. She cannot be a party. Whether her mother is a necessary party or not, that's for you to decide. But she cannot be a necessary party.
That is, my lord, is the question which is recorded in the impugned order submission. My lord, kindly go through the.
That's the reasoning in the impugned order.
Yes, my lord.
So there is no infirmity, madam.
No, my lord.
It tallies with my observations. Cannot be. If there is no cause of action from the scope of the suit, the defendant number 6.
Other misconducts are there. Several.
Or other misconducts, that's not the prayer in the plaint.
Yes, my lord.
Where is the prayer in the plaint? You have only paid for.
Shift to the paragraph number 49. My lord, here in this plaint, all other claims are relinquished.
Madam, only your subject matter of challenge is the deed of conveyance. So you have prayed for declaration that this deed of conveyance is void, set aside, whatever it might be. So only the persons who are parties to the deed of conveyance, they are only
the party who bought the suit, who bought the deeds, who is the purchaser, she never.
And how the defendant number 12 is related?
They never visited the suit property. Defendant number 6 and 12 visited the suit property.
Visiting cannot be a ground for making them a party.
And my lord,
Unless you have implemented some persons.
My lord, the how the suit will be adjudicated.
That is for you. Carriage of proceedings lies with you. Considering the nature of this suit property and the scope of the suit, they are not necessary parties.
Relinquishment is there, my lord. Under order to rule 2 in paragraph number 49.
Not relinquishment.
For damages, mesne profits, other.
Relinquishment.
Yes, my lord. Other.
You want to relinquish some of the prayers. Which prayer you want to relinquish?
My lord, the plaintiff filed only the legality of the deeds. Nothing.
Madam, I have to consider only as per the prayers in the plain. I cannot go which prayer you will be including thereafter. I cannot.
My lord, the impugned order has instructed the plaintiff to file the amended cause title on the next hearing, 21st August. No scope for addition of party is given.
That is already there. For that, if you are entitled to add the parties, I make it clear that as per the law, you will be entitled to take step. All right.
6 has
By the order.
Friday, my lord, due to some personal difficulty in my family. The divisional petitioner, my lord.
On the prayer
No, she has got a copy. Monday. My lord, in that case, my lord, it will be your lordship's pleasure to fix a time. I'm not on.
fixing time is difficult.
Huh.
On the
Millard applicant Millard leave. Millard has directed Millard to file in the department, and the matter Millard will appear on Friday. Department Millard is saying that they need an writing in that effect. The fact sheet Millard. Told.
To move on.
It-
Yes.
May I pray one indulgence, my lord? My lord, may I pray one indulgence? My lord, item 44. My lord, yes,
Item number?
44.
Yes.
My lord, I have some personal, so my lord, may I leave, my lord? Mrs. Bagh is for the other side.
Yes. What do you want?
My lord, it is taken up tomorrow or day after, my lord.
All right.
Day after two,
Day after tomorrow.
44 not tomorrow.
Friday.
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 I'm good.
Yes.
May it please your lordship. Well, it is a application for expeditious disposal for a second time. Well, it's a suit for declaration and injunction. Now, why we have come before your lordship for a second time is that from 2010 we are suffering, my lord, a status quo order. My lord, now the plaintiff, my lord, in violation of status quo order, has, my lord, constructed a banquet hall and is running the business. Now, my lordship, initially at page 198.
What is the stage of the suit?
Stage, my lord, stage written statement filed, my lord. Now two applications are pending, which are very important. One is for local inspection and one is for demolition of this banquet hall, which has been constructed in violation of the status quo order. My lord,
17th of August is fixed for hearing of what? Petition dated
of the vacating application. Of the vacating application.
injunction vacating.
Yes. My lord, lordship, kindly come to page 198 is the earlier order. It's a
So
second.
that is vacating the injunction. And where is that application for demolition you have said?
Well, I have first file an application for local inspection and vacating.
Local inspection, conjoint prayer in one application.
No, there are two applications.
But the order sheet says 17th of August has
There
been
are
fixed.
multiple applications pending. Even order 7 rule 11 is pending. Well, the problem now, well, the urgency, because I approached before your lordship second time is that, well, kindly look at the last page 223. Well, the complete banquet hall is running from there.
91 আমাদের application
You are earning.
No, I am not earning.
some other person এটা
I am not earning, my lord. The plaintiff is earning.
This application under Article 220.
Grateful, much.
Lordship, this is
Yes.
my application, Lordship. This is an application that's been filed for rejection of our claim to file additional written statement.
Claims tribunal.
Yes, sir.
Additional written statement rejected. Why?
Your Lordship, as the PW.
Who are you?
I'm the insurance company. PW closed, at the stage of OPW, the court has refused stating the fact that as in the PW stage, we cannot allow the same. Your Lordship, kindly come to the impugned order, 3/11/2025.
No, have you sought for leave?
Your Lordship,
Order 8 line.
Your Lordship, kindly come to the in the written statement, there is a prayer for leave, Your Lordship.
Where is that?
Lordship, the written statement is here, Your Lordship. The certified copy of the.
No, not in the written statement. You have to seek leave under Order 8 Rule 9.
There is no special leave, no specific leave has been granted. At the time
Then-
of filing the writ petition, there is no specific.
No, then Order 8 Rule 9, you have to seek leave.
No, there's no, though there is a prayer to it, but that specific leave has not been
If you
granted.
seek leave, then I can say this cannot be
In the prayer
interpreted.
portion, there is a leave, Your Lordship.
Where is the prayer portion?
In the written statement.
That is neither here nor there. Ashun, this application. One two zero two 1003. Yes.
My lord, this is my petition, but appearing at the instance of my learned senior friends, my lord.
Yes, yes.
My lord, this is my application, but it is appearing at the instance of my learned senior friend.
আমরা suffering.
My lord, they
You are not notified.
Yes, notified.
notified my long back. It
Long
suddenly
back.
come up.
Kindly, for the timing, kindly peruse the lordship's order. ঠিক আছে, kindly peruse the lordship's order.
Did I pass any order?
Unusual. তো যেরকম জিজ্ঞেস করলো আছে না order, তার মানে unusual হবে নিশ্চয়ই।
So this is injunction against injunction.
Not in so many words, my lord, the receiver was appointed, my lord,
That was not under challenge here.
we, my lord, considered that for the timing, we will not take possession in spite of the dismissal of the proceeding.
So what is the impugned order?
My lord, there are two impugned orders. One is pertaining to appointment of a receiver. And the second, my lord,
Appointment of a receiver, how revision is maintained?
my lord, it's from an appeal.
Come on. The maintainment point is correct.
Lord, I'm being led by Mr. Mukherjee.
Kindly come to the last portion of your lordship's order.
Calcutta order গুলো দিন।
You are referring to order dated 22nd of
The only
September,
order passed by my lord.
22nd of September 2025.
My lord, my lord.
Last
Come,
portion.
sir, last
con-
portion.
Considering the fact the receiver was in possession and running the business, this court insisting of this interest during the pendency, the receiver is allowed to, the receiver is directed to keep. So this is done.
This is not done. That's
Kindly
all.
have a look into the orders. I'll file an affidavit, certainly not to disclose.
No, you have filed your.
I have not yet. Pursuant to.
Yes.
No,
Can you-
I am
can you
not the
vacate-
receiver.
can
The
you vacate
receiver
any-
has already filed. That is recorded
I've
in the
said-
trial court's order.
Receiver filed.
Yes, that's the trial court's order that I have. আমি দুটো কপি দিয়ে দিলাম বোধহয়। Sorry,
Receiver files monthly accounts as stand on 28th February 2023 to 31st March 2023.
Mr. Mukherjee, which order records?
I have handed over both the copies.
Oh, yes, this.
29th July.
29 July, yes.
Can you see the second, third, last but one
Receiver
paragraph?
files monthly accounts as stand on such and such.
Yes, kindly come to the receiver files monthly accounts as stand on 20th February 2023 and 31st March 2023. Thereafter, nothing.
Yes, Mr. Mukherjee, this is of 2023. But
And
thereafter,
Lord,
I tell you, Lordship, the receiver was appointed, Lord, in 2020.
Why
Thereafter,
is it
Lord, my Lord's order was, Lord, that bi-monthly was in September 2025. So, Lord,
yes,
on September 2025, your Lordship directed that he has to file bi-monthly. Lord, from then onwards, Lord, he is filing the bi-monthly one.
but it has not been recorded. It's as stated on 28th of
This is order
February
dated 29th
2023.
July.
Thereafter, Lord, there is another page. Lord, may I just take over, Lord, one of the copies? Both the copies have gone.
আমাকটা নে না এই তো নে না
আমি ওখানে মার্ক করা ছিল
29th July order is the last order probably.
জজ সাহেবের কপিটা কোথায়?
No, you have given these two copies.
No, one for my lord. One for my lord.
তারপরে
Mr. Mukherjee, please do one thing. Please show it to Mr. Basu that you have.
Yes.
That is
He is
this
not the
is
receiver.
complied with.
No, I am not the receiver.
No.
The
He is
lawyer
not
is
the
there.
receiver, but he says that the receiver has
Yes.
complied with.
I have considered only on that ground, on that date.
No, Mr. Mukherjee, the order dated 20th of February records no compliance has been made by the receiver, yet in spite of specific direction of the Honorable Calcutta High Court. That's the order dated 20th of February 2026.
This we apprehended. Apart from that, Malad, the running business that
The
should not
next,
be-
yes,
funds are there.
24th of December also 2025 also records that has not filed any statement of accounts till date.
No, your lordship will kindly have a look at order number 81, 30th of April 2026. One preliminary account report is filed.
Oh, that is after 20th.
2022.
No. Thereafter, one report, preliminary report is. But why a preliminary report? Preliminary account report.
But that is the reason, Lord, I want to, Lord, bring forth, Lord, the accounts and to place it before your lordship, Lord, what accounts have been filed by the
He
receiver.
is defaulted, my lord. On
Lord,
that ground,
whether
what
he has
order should go?
defaulted or not, Lord, it is, Lord, I have to take instruction from the trial court. Come before your lordship by you have an affidavit.
Orders are here. In the trial court, my learned friend knows better than me that if any single paper is filed, recorded. 29th July's order is before my lord.
What is the order on the challenge here?
Two orders, sir. Receiver were discharged, my lord.
Yes, when can both of you come ready?
Lord, I can file, Lord, the opposition, Lord, to the vacating application that my learned friend.
No,
Getting
that-
application.
Nothing, my lord. This
Getting
is application. I am saying this is an application for non-compliance of this order. You prayed for dismissal of the receiver, the divisional application. I cannot press it, my lord. Can you hear it out?
Yes, so basically it's to get the civil division application.
Then your lordship
hard.
will kindly, Lord, that is, kindly fix the date and come
That's
ready.
the advice given by Mr. Basu.
Not at all, not at all, not at all.
Very well.
Advice given by Mr. Basu to take out this application.
Then, Lord, it is understood that
we
they are not pressing for this application, but on the merits of, Lord,
We
the
are having a
revision
handle that the report has not been filed. This is the handle we had. Otherwise, this application alone
But
or
kindly
the,
fix any day, Lord, that your lordship.
the application may be on record, but you also can hear
I'm
the
directing this.
Then, Lord, I have to use an affidavit, Lord, to the applications that my learned friend has. Lord, because
This vacating.
affidavit,
That
no
Vacating,
affidavit.
what has
can
been
fix
stated there?
Whatever.
Affidavit,
no affidavit, file it.
Mukherjee, what affidavit will be filing? So I will take up the hearing of the civil revision application.
I'll bring forth the document, whatever.
So you bring the documents that the accounts have been filed, please serve a copy upon them.
How is possible? 29 July says not filed. Mr. Mukherjee's client will manufacture this today.
No.
ना बोलना तो क्या बोलेंगे तो 29 July order monthly account of 2023.
No, but these orders are also confusing, Mr. Basu, because some says this order of April says some reports have been, some accounts have been filed.
That report is with me. That report is with me.
All right. Mr. Basu Lanet, senior advocate appearing for the opposite party number or all opposite parties?
I am astonished. It's a hotel business, my lord. 3 lakhs rupees is the only income, my lord. How they are carrying on this proceeding, my lord?
Will you do you want to carry on with this business, Mr.
I have to.
Please think over that.
I will carry on. I personally, Mr. Basu, can you appoint me receiver? I will carry on.
Mr. Basu Lanet, senior advocate appearing for the opposite party, submits that in spite of specific direction passed by this court on 22nd of September 2025, till now we could not get this hard.
Which one?
Civil revision application.
Yes. That is the reason, Lord, he has come up with that. Judges are so bad nowadays, they could not take up this matter for hearing. What can be done, my lord? I don't have this complaint, Lord. Your Lordship has disposed of one of my matters today. My God. Even it As could a be lawyer, mentioned. I cannot. As a client, I'm saying. My matter also some matters disposed of.
22nd of has not complied with the directions contained in the order dated 22nd of September 2025. Mr. Mukherjee Lanet, senior advocate for the petitioner, seeks time to revert back with necessary instructions with regard to such allegations.
Slot bar करूँ आजकल तो slot लगे.
How much time both of you will take? Conservative estimate.
30 minutes max. Maximum. I cannot be more than that.
3:45.
3:45. Excepting Friday.
Friday I can make it 3:30. 3:30 on Friday you can get half an hour and half an hour.
My lord, we have been saved by the ILS. Otherwise, we are in difficulty.
Mr. Basu, otherwise only one thing, it's difficult to take up hearing matters on other days. Because you know the pressure, because otherwise you will be coming up.
My lips, sir, my lord.
Don't know the rush on Monday morning.
I know. My lips, sir, want to say something, but I cannot say in open court. If we meet personally, my lord, I will say. And my lord, I'm sure my lord will have no answer to that.
But only one thing, because
এক লাখ রিপিটিশন করে এখন 25,000 রিপিটিশন সার্কিট বেঞ্চ নিয়ে
19th of August,
কি বার
Wednesday, 3:45 লিখে রাখুন তারপর।
তারপর দেখাই। But in the meantime, may I use an affidavit
To what?
to the applications that because
You want for other purpose, Mr.
No,
Mukherjee, you
not for
can
other purpose.
do
Lord,
that.
I really require Lord, those documents, Lord, whether it has been filed or not. You cannot develop than that of the court's order.
It will be open to the petitioner to.
I'll not, Lord, let it.
If you want, Mr. Mukherjee, you can come up with an affidavit.
It is so that I will deny.
But before the next day, please serve a copy upon, then I will accept.
Mr. Mukherjee made me know that these accounts have been filed on particular date.
Yes. Call the next matter.
Grateful. Grateful.
Item number 2172.
Yes. 2172. Who is appearing? Hey, not today. Not today. Next.
Item number 48.
Please, Your Lordship, this is beg to appear on behalf.
No caveat. Yes, what is this matter?
Impugned order, my lord. Section 4 proceedings. There is a stay by the appellate court on an order of eviction. Section 7 has almost come to an end and they want to, my lord, proceed, my lord, with the passing of the order. They cannot do that. Section 4 stayed by the appellate court. So if I am an unauthorized occupant or not, that is to be decided by the appeal court. And the order passed by the estate officer is stayed, my lord, by the appellate court. Looks to 103. This is the unauthorized occupants act. Have a look at 103. That the operation of the impugned order be stayed till the next date fixed.
What is the impugned order?
The eviction. Eviction.
Where is that? Have you annexed that?
That your lordship will find. Kindly seize below 101. And the order, my lord, there is at 47. And the ordering portion, my lord, is a little late.
Order is at page 47.
Yes.
The impugned order which was referred to there.
Exactly. Kindly have a look at the ordering portion of that because your lordship need not trouble my lord self. 55, it starts 56 and then the memorandum of appeal is also annexed at 57. These were not documents very required, but even then.
So this has been stayed.
Yes. So the
56 has been stayed.
So whether I am unauthorized occupant or not under section.
You have a copy of the PP Act.
Yes, have a look at it below. I have it.
Open it.
Where any person lordship is going through. And then, my lord, notice is on 7.3. So what the court needs to come to a finding here is, my lord, if I'm in unauthorized occupation, areas of rent is not the issue here.
But if you are in occupation, areas of rent payable,
That's a separate aspect altogether. This is on damages. This is a notice on damages.
Where is that? Please show me.
109. Kindly have a look at that.
109.
This is the notice. This is a notice
7.2.
7.3. 109 top. Form of notice under subsection 3. That's fine. Then kindly cease powers under section 7. Damages amounting to rupees at. That's the wording.
You could have replied to the show cause notice. Then what?
The court is now passing an order. Like looks to the last page of the order. The court cannot do that. I have not come up before your lordship till the evidence is over. I have not. But now the court has fixed it for my lord passing of orders under section 7. That they can't.
Where is that?
Right at the end of the below, it's said 21st of July 2026. 1st July. 1st July. I'm sorry. My
First of July.
Yes. Looks to the last order. Last page rather. And then both parties shall place their submissions, heard the submission, hearing of the
Both
matter
parties places their submission.
Cannot do.
Submissions recorded, hearing concluded.
That's what I'm saying. In a partition suit, preliminary degree is under challenge. Final degree, my lord, is being passed. Can't happen. This is why I'm before your lordship. That's exactly why I'm before your lordship.
Yes, yes, what is this matter? Please start. Start. It prima facie appears to this court that yes.
Madam, Madam Teresa. Previously, writ petition has been filed.
why are you not allowing your juniors to move? He said that you have asked him not to move. Yes, start. Yes.
Madam, initially a writ petition has been filed before this honorable court challenging that by construction, saying that unauthorized construction. In the writ petition, an administrative order of injunction has been passed. Now, my lord,
Local investigation is necessary, Mr. Mukherjee. Why?
I'm showing to local investigation commission. I'm telling you, lordship.
Engineer commissioner, according to you. Engineer commissioner is necessary.
No.
Then why?
I'm telling you. Now, my lord, first of all, my lord, against that an appeal has been carried out. Ultimately, my lord, the writ petition has been dismissed. Now, my lord, they preferred an appeal. Now, my lord, we also preferred an appeal because there is some observation in the order. In the appeal court, the division bench presided by Justice Banerjee, my lord, asked the corporation to submit a report. Municipality, Boidgobati municipality. Boidgobati municipality submitted a report by showing there is no unauthorized construction and construction has been made strictly in terms of the sanction plan. Thereafter, my lord, they challenged that report. Again, from this honorable court, a person went, engineer went, and ultimately filed the report. From that report, it will appear that, my lord, the construction is absolutely correct. Then
It
when
prima facie appears to this.
municipality.
Yes.
For the petitioner, my lord, expeditious. Expeditious disposal.
Of what?
Order 6 Rule 17 application, my lord. Amendment application issues were.
Section 17.
Order 6 Rule 17, my lord.
Order
Amendment
6.
application.
All right.
My lord,
Amendment of what?
amendment of the plain, my lord. I am for the defendant, my lord.
You are for the defendant.
The defendant number 1 in the suit, my lord. Suit proceeded. Issues were framed.
What is the nature of the suit?
It's a suit for injunction, my lord, and specific performance. Specific performance injunction, my lord.
This application under Article 2 Yes.
My lord, it's a partition suit
Yes.
filed by the plaintiff, and as per the petition filed by the plaintiff, under order.
What do you want?
I want expeditious time.
Expeditious hearing of the suit.
Yes.
Partition suit.
Yes.
What is the stage of the suit?
Stage of the suit for filing amended claim by the plaintiff, but they are taking
Ad
adjournment.
interim or injunction application is also pending.
No, injunction application has been allowed.
When?
My lord, it was allowed at the initial stage of the trial.
No, that was ad interim.
Ad interim is allowed.
Temporary injunction.
Temporary injunction is allowed. No permanent injunction has been allowed because hearing has not been taken.
Sir, ad interim passed. Injunction application was pending as it appears from the order dated 26/11/2025 when the injunction application has been disposed of.
My lord, injunction has not been disposed of.
That is what I am saying.
Has not been disposed of.
Asun. This application under Article 2. Yes. This is what is this matter? Yes.
Petitioner enter into a registered partnership deed. Kindly page 27 with that different.
What order you are challenging?
The order dated on 9th June 2026, my lord.
Suit abated.
Yes, my lord. This is the fact. Fact is that, my lord, we have
Suit abated. How can you challenge in a civil division application?
No, my lord. There are two defendants. That after servicing the copy that's returned as deceased. After knowing that from the court, we have filed an application before the learned court below. And if you look kindly to the next order, that is on 1st August.
So you have filed a miscellaneous case.
We have filed.
So that will be disposed of.
If my lord kindly see the order dated 1st August. The difference between the two orders, my lord. Kindly come to page 85. My application, the miscellaneous case. 84.
What can be done? You have filed a miscellaneous case against the dead person. Can it be done? Yes, for that it was dismissed. What is that there is bad for defect of parties?
Until and unless the subsection be allowed. My lord, kindly come to page 86.
Sir, can you plead a dead person in a proceeding? You have filed a proceedings miscellaneous case against a dead person. Can you do that?
Cost title, how you will write, my lord, in the cost title, my lord? We cannot change the cost title until unless substitution is allowed.
Can a dead against miscase against a dead person can be filed?
In the original suit, there is a cost title against the Ravinath's Hembro.
What are you saying with the cost title?
Kindly make it not today. I will satisfy it. Make it not today, my lord.
Why?
Let Mr. Samuel argue, my lord.
Where is the
court number 3, my lord?
Ask him to come, pass over. Next.
Item number 32.
Yes.
Defendant is the petitioner before your lordship, my lord. At first, my lord, kindly see page 15, the prayer, my lord. Page 15.
What are you challenging?
My lord, I am challenging, my lord, the part decree has been, my lord. 151 petition, my lord, cutting the tree has been allowed, or cutting the tree has been allowed. That is, my lord, the subsequent, my lord, it amounts to dictate the suit partly.
1st of July 2025.
Yes.
That order you are challenging.
No. 1st of July 2026.
1st of July 2026.
Yes.
In the prayer portion, you have mentioned 1st of July 2025.
Come on, liberty may be given to.
1st of July 2026, you have challenged.
Yes. 26. Liberty may be given to correct this.
Yes.
My lord, kindly see, ordering portion, my lord, kindly see. There is a, my lord, birth and privy of mine. My lord, kindly see the last portion of the order. In the event, if any damage is caused to the defendant's bathroom or any other adjoining structure of the defendant during process of removal, the plaintiff shall restore the same to its original condition at his own cost within such reasonable time as may fixed by this court is different. My lord, bath and privy, it's, my lord, daily use is the my fourth to it should be, my lord, restored. And another, my lord, kindly see the prayer of the suit partly decreed. Page 15. Paragraph 9, my lord, prayer. First prayer, my lord, kindly see. A dictum for declaration that the plaintiff is the absolute owner of the A schedule property and the C schedule passage and drain being common has every right of the plaintiff to exercise all kinds of right, including cut down the banyan tree by entering therein. Partly decreed the suit.
Sir, it is for your benefit also. If the banyan tree, if it is in such a way,
yes, my lord,
it will also destroy your bathroom.
Yes, that is true. That is true, my lord.
Then
fourth to it, my lord, that should be, my lord, if
that is the direction passed upon him. Otherwise, if it is stayed, then it may, in its normal course, it may be destroyed.
Actually, my lord, what happened, my lord, kindly see, my lord, fourth to it, if damage is caused, then fourth to it should be, my lord, restored.
That is the order within such reasonable. What is the expression forthwith? How much time? It says reasonable time. Otherwise, if it is damaged by normal process, then you are gone.
That is there.
Then it's protected, reasonable time, and the commissioner in presence of the commissioner. Even then, you are challenging this.
And my partly dictate for that reason, if suit.
Sir, if I stay, will it any to your benefit? Please apply your mind. So banyan tree, it is for the purpose of cutting. If it is destroyed, it means it has already destroyed your bathroom.
Some portion is.
Then Then what do you want?
As your lordship desire.
Uh,
Expeditious disposal
of what?
of a matter, OC number
Of
of a suit for declaration and recovery of khas possession.
what is the stage of the suit?
Peremptory stage, cross-examination is going on. Next date is
This application under Article 227 of the Constitution Before. None appears for the petitioner at the time of call.
For the petitioner, your lordship.
Yes.
Lordship, I am the plaintiff of the in the title suit number 344 of 2024, which is suit for declaration specific performance of contract and permanent injunction, your lordship.
What do you want?
Lordship, my submission is 2000. My submission is lordship title suit 345 of 2025 to 2024, which is pending before the learned trial court at early pori, your lordship. So the kindly direction upon the trial judge to dispose here and dispose of the matter within 6
Yes,
months.
madam, why are you getting nervous? This application under Article 227 of the Constitution of India is that the status quo order. Yes, this application under Article 227 of the Constitution of India.
This is my application. Preemptive petitioner before your lordship lost in both court. After my lord 3 months, 24 days, it has been filed on the point of co-share. It has been granted, but this is not the co-share and not belong to us. Same under the same kutia. This is my execution filed. My lord, at this March I have come in. Give some reading.
What is your point?
My lord, point of limitation and my lord, the
Point of limitation. It was time barred when it was filed.
3 months, 24 days, it has been observed in the trial court judgment.
3 months, 24 days. Show me that.
My lord, kindly come to
In the trial court's judgment.
in the trial court judgment.
Yes, please show me.
My lord, trial court judgment which after the points of consideration. Yes, my lord, point number 2, just before point number 2 in the judgment. Inner page 7. It clearly appears that the petitioner has filed this case after expiry of 3 months, 24 days.
No, but it's a case of non-notified co-sharer. Limitation is 1 year.
But this he is not a co-sharer. He is not a co-sharer.
He's not a
He is not
co-sharer.
a co-sharer. This is my point.
Please show me how that point was decided. Please show me the finding that he was not a co-sharer. What's the finding on fact? In 227, factual finding unless there is perversity.
Absolutely.
Please show me
Absolutely.
what's the finding on facts with regard to co-sharership.
My lord, point number 2. May I please?
Point number 5 and 6. Petitioner has successfully proved that he is a co-sharer in the suit plot, whereas opposite party did not have.
Conclusion. My lord.
Yes.
Explanation.
What explanation?
Point
This is
number
the finding of fact.
My lord, point number 2, the next point to be determined whether the petitioner is a co-sharer to the case line. To prove
Please show me the appeal court's judgment. What point you have raised with regard to co-sharer and how it was dealt with.
Not dealt with properly. India did, my lord. His name has not been mentioned in, my lord. The
Record of rights produced. His name was recorded as a co-sharer. Appeal court has found. This application under Article 227 of the
Item number 37.
Yes.
Lordship, I appear for the petition in this matter. This is my application praying for expeditious disposal of an application for injunction, my lord. I am the defendant in the suit, my lord. The difficulty is that the bank is suffering injunction order from last 2 years. Not a single penny is being paid, my lord. And now the next date is fixed in February 2027, my lord.
This application under Article 227 of the February 16th February 2027.
My lord, this is my application.
Yes.
I'm praying for expeditious disposal of my section 151 application pending before the
What
learned.
is the 151 for? Who are the learned advocates appearing in the trial court?
My lord, in trial court, my senior was appearing before the trial court.
What is the name of your senior?
Mr. Shukrit Mukherjee.
And other side?
And other side, I'm not.
Not today, please inquire and then.
My lord, there is no caveat. I'm praying for expeditious disposal of the.
Sir, please ascertain the learned advocates who are appearing for the respective parties tomorrow. Yes.
Pass. My lord, my senior
Yes.
is out of state, my lord. Please fix it. Not today, my lord. My senior is out of state.
Yes, yes. You are here. Yes. What is this matter? What is this matter?
Petitioner, my lord.
An adjournment has been sought for on the ground of the learned advocate Yes, Dr. Yes.
So this is regarding order passed by the building tribunal for deviation of construction of slab, RCC slab in the ground floor of the petitioner.
Appeal dismiss.
Yes, my lord.
Demolition.
When the construction of
What's the infirmity in
No,
this order,
only-
Mr. Chakraborty?
Can you see what is happening? The petitioner is an advocate of this court, my lord. The member of the bar, the petitioner.
Petitioner?
One of the petitioners, the member of the bar. Yeah.
Mr. Chakraborty, that is
Kindly-
very.
I have got several things to be argued. Can you see? I have prepared short points, notes of points. Can you see? Go through these points.
If there is a violation of the mandatory open space, Mr. Chakraborty,
No,
it's
nothing,
difficult.
no space is violated.
That's the finding.
Sorry?
Mandatory open space.
And inspection will be made. No inspection has been made. No report has been provided.
This is Kolkata Corporation.
Yes, my lord.
Who is appearing for the
Mr. Gupta, I am appearing for this. Inspection has to be made, madam.
No copy of the report.
No, yes. No copy has been given.
7th of July.
Yes.
All right, serve and come back.
তো ঠিক আছে ওকে ওকে সার্ভিস করতে হবে সার্ভিস
The come 19, nothing will done. They will not take steps. Yes, call the next matter.
My lord, in item number 37, my lord has granted an order for expeditious disposal, my lord.
Please wait. Yes.
Affidavit of service has not been filed.
Affidavit of service expeditious hearing.
Yes,
Why
my
will
lord.
serve?
My caveat was there, my lord.
Aviator was there.
Yes, and my lord, next date is before the planet court below is fixed in February.
But please wait. Please wait. Item to bar করে রাখুন কোনটা? Yes. Yes, Mr. Nag, you are appearing.
Yes, I am for the petitioner, my lord. Very
My lord.
short matter.
Yes.
My lord, at the outset, I would like to submit that seeing the matter in the list, I have been instructed on behalf of my client to appear, who is the opposite party in this proceeding. No copy has been served. If a copy could be served, my lord, and
There is no caveat.
there is no caveat, I agree, my lord.
Mr. Nag, please serve a copy.
Yes, I will serve.
I am for the petitioner.
42, Lordship, I am for the opposite party, Lordship. As per the instruction, we are appearing after seeing the cause list, Lordship. I am led by Mr. Sanjeev Boni. Lordship, kindly direct to serve the copy and take thereafter, Lordship.
He admitted first, thereafter he
Lordship.
serve a copy. There was no
Be
caveat.
admitted. Are you sure that it will be admitted? If it is dismissed, you are taking that risk. Yes, then move. Yes.
For eviction and recovery of khas possession, my lord, I am the defendant over there. My lord, we had filed a written statement. Thereafter, they filed the WS. Thereafter, they filed their amended claim stating of a existence of an alleged deed, trying to show their reasonable requirement. Now, my lord, during the PW1, after it was completed, they wanted to recall the evidence and they wanted to.
Yes, it's a well-reasoned order considering all the decisions of the Honorable Supreme Court. Recent decision, I think 2-3 days back. Have you considered that? What remains?
My lord, with objection, my lord, if that is not.
What objection?
My lord, that deed of gift, I am objecting to that thing, my lord. Only that, my lord.
What objection?
That.
The marking of the certified copy.
Yes.
Please show me the evidence that you have raised an objection at that point of time.
In my written objection, I had stated.
That will not do. When it is marked as an exhibit, you have to object. If you have not objected, if an application for recalling has been allowed, it has to.
That matter, I had raised my objection, my lord. That was.
Please show me from the evidence that you have.
That is the difficulty, my lord.
Nothing. This application matter.
My lord, may it please your lordship, my lord. This is the second now round of civil divisional application.
Beneficial to both of you.
Yes, my lord. Beneficial to both
My
of
lord, I, my lord, appear for the petitioner.
Oh, beneficial to you also, Mr. Dotto.
Yes, Mr. Dotto is.
Yes. Say, second round benefits me.
Yes, yes. Second round benefits you.
Yes, my lord.
Me as well.
Yes, that is why. So both of you. So I did
Yes.
not see Mr. Dotto. He joined a bit later. That is why.
Yes, my lord.
Yes, yes. What is this?
Now, my lord, in respect of a public premises, my lord, order of eviction was passed. Then, my lord, after the eviction order was passed, my lord, in between, my lord, a suit was filed by, my lord, the unauthorized occupant, in which, my lord, there was an injunction in the form of status quo as regards, my lord, nature, character, and possession. Then, my lord, and a PP appeal was filed, my lord, against, my lord, the order of eviction. Now, my lord, in the PP appeal, my lord, according to us, my lord, the appeal is barred by limitation. Be that as it may, I'll take it as my second point. But if your lordship may kindly take, my lord, page number 46.
Page number?
46.
Yes.
May I place this order, my lord? Today is fixed for application for stay. Learned advocate for the appellant submits that in compliance of the order of the estate officer, a sum of rupees so and so has been paid. So he needs an order of stay. Otherwise, the purpose of filing the instant application will be frustrated. Learned advocate for the court undertakes before this court that execution will not be proceeded at this stage, but prays for early hearing of the appeal. It appears from the impugned order that if the above mentioned payment is made by the appellant, the port authority will not be entitled to proceed for execution. It is the case of the appellant that the payment is made as mentioned above. Under the above facts and circumstances, no order of stay is granted at this stage. Let the case record be transferred. Thereafter, my lord, day in and day out, my lord, the matter was
payment made, but no order of stay.
Undertaking.
No order of stay.
To the third paragraph. He's given an undertaking. That's why no order of stay is granted.
No, let us see. Let us see what was the undertaking. We'll go into that.
No, payment is made. It has been stated.
It has been made.
Yes.
Paragraph. Learned
Yes.
advocate on behalf of Shama
Execution will not be proceeded with.
Yes.
151. Mr. Chatterjee, why are you getting agitated? Something wrong, Mr. Chatterjee?
Your lordship knows what's wrong with me, but that's all.
Please take your seat.
Why he's in a hurry to go back home.
I assure you.
No, Mr. Chatterjee is in some difficulty because the way I found that he is getting agitated, he really does not go. But yes,
Otherwise, he's very sweet person.
yes, yes. Now, yes, that is why I asked him why he's getting agitated. Yes.
Now, my lord, what happened is that this is the order, my lord, which was passed, and my lord, thereafter, my lord, the matter was transferred, and my lord, on various occasions, my lord, the matter was not, my lord,
What do you
taken
want,
up.
Mr. Dotto?
Now, my
You
lord,
want
what
the
happened
appeal
is
to
that
be disposed of.
No. Well, that round is over. That was in the first round. Now, what happened, my lord? The injunction, my lord, which my learned friend's client was, my lord, enjoying. My lord, please have a look to, my lord, page number, my lord, 44.
Page number 44.
This was a suit filed by them, by Mr. Chatterjee's client.
Yes.
Now, this is dated, my lord, 23rd of December, 2024.
Yes.
The ordering portion, kindly have a look at both the plaintiffs and the defendants. This suit, along with their men and agents, are hereby directed to maintain status quo with regard to the nature, character, possession, etc. Now, in the suit, we go and apply under Order 7, Rule 11, saying that this is a public premises, public property, therefore suit is not maintainable. Where my Order 7, Milord, was allowed.
Order
And
7
Milord,
allowed.
Yes.
Order 7, Rule 11 allowed.
Allowed.
Then what happened?
Then, Milord, I had taken possession. Milord, I had taken possession on 1st of July 2026. Now, after I take over possession, Milord, Mr. Chatterjee's client Millard filed an application under section 151 before the PP Appeal Court, praying for an order of restoration of possession, which has been allowed by the order Millard under revision. Now, please have a look to the order of 28th of July 2026. But in between, Millard, there was a 227 application for early hearing, but I'm not troubling your lordship with those.
28th of July 2026.
Yes, Millard.
That's the impugned order.
Yes. No, Mr. Dotto, I missed out somewhere because you told from the order of the estate officer, a miscellaneous appeal has been carried by Mr. Chatterjee.
Right. Yes,
by Mr.
Millard.
Chatterjee. Then in that
Yes,
proceedings, there was an undertaking given by you that he will not proceed with the execution, and they have also deposited some amount.
Yes.
Now that
When
miscellaneous, no, they have deposited.
non-deposit,
No, they have,
yes, they have
deposited. The
but-
order records.
Till date, every amount is deposited. Till
No,
date.
the order also, Mr. Dotto, which you have referred to, it says that it is the case of the appellant that the payment is made as mentioned above. That submission
Right.
was recorded. So that
Right,
so
but that is
has
not
been-
the only ground of eviction.
No,
That is not.
that is one thing. So now, in the appeal, you undertook not to proceed with the execution.
Yes.
But thereafter, you told that you have taken possession. How?
Yes, that is what is Millard is to be decided by your lordship. Number one is Millard. When Millard this undertaking was given, Millard, that undertaking, Millard, was not a continuing undertaking. Millard, it records that at this stage we will not execute. The learned judge Millard records that okay, I'm not granting any stay again at this stage. Now, Millard, the stage changes when Millard the status quo order goes. That is Millard my order 7 being allowed. Now, Millard, the question is whether
Order
Millard,
7, Rule 11 allowed is in the suit, which was
Right.
filed by Mr. Chatterjee, and wherein he obtained an order of injunction. That's a separate chapter. Suit plain rejected. Whether he has challenged that or not, that's a separate chapter. Now,
Yes.
here, according to you, you have taken possession of the public premises in the meantime. And Mr.
Yes.
Chatterjee has filed an application paying for restoration of possession.
Right, that has been allowed.
So that has been allowed. So that's
Yes.
the order under challenge.
Right. Now your lordship will kindly take, Millard, the reasoning, Millard, of the learned judge. Kindly take note paragraph number 11 onwards.
Yes.
The court issue for determination is the legal effect of the undertaking given by the respondent to the court. The undertaking of the respondent was clear. Execution will not be proceeded with at this stage. This was not a casual statement but a solemn promise made to the court on the basis of which the court proceeded. The learned district judge did not pass a stay order precisely because of this undertaking. The court placed its faith in the commitment of the respondent. The respondent was bound by this undertaking as an officer of the court. It is a fundamental principle that the courts rely upon such undertaking, and any breach thereof undermines the administration of justice. The respondent has argued that the undertaking was time-bound at this stage, while it is true that the undertaking did not have the effect of perpetuality. But this is very important. The phrase "at this stage" in the context of order refers to pendency of the appeal proceedings. The appeal was admitted and pending before this court. The court, relying upon the undertaking, passed the order, meaning thereby that the respondent was not to proceed with the execution until further orders from the court or until the appeal is disposed of. This is, Millard, with respect, contrary to, Millard, what your lordships have held in other courts, in other matters. If it is interpreted otherwise, it would render the undertaking meaningless and undermine the judicial process. Having induced the court to withhold a formal stay order based on its promise, the respondent is stopped from acting contrary to it. The respondent has not disputed taking possession on 1/7. The manner in which possession was taken, that is by breaking locks and forcibly sealing godowns, was not done through a due process of law. The respondent did not seek leave of this court, nor did it inform the court of its intention to execute the order. The mere passage of time does not by itself release the respondent from the binding nature of the undertaking given to this court. The appellant has invoked Section 151, which preserves the inherent power of the court. I don't dispute paragraph 14, but this is
Mr.
on law.
Mr. Dotto, only one thing. According to you, the undertaking was given
Yes, sir.
on a particular date, for that date, or for a brief period, if it can
Right,
be.
right,
So
right.
it was not a continuing one. But good,
Right.
bad, indifferent, the proceeding was pending before the court. So,
Yes.
what prevented you from approaching the court saying that, look, undertaking was given on a particular date, they cannot enjoy the property they cannot enjoy the possession unconditionally. What prevented you from approaching the court with that prayer?
But on the other hand,
pending undertaking was given, says that execution will not be proceeded with, that also do not record till which date. Mr. Dotto, it's
Yes.
better now only one thing, Mr. Dotto, to cut the matter short.
Yes, sir.
One thing is that you may be saying that they cannot be entitled, or they are not entitled, or they cannot enjoy possession or enjoy an unconditional order of stay. That's one thing. So they can be put to terms. So for that, we have to see whether the opposite party can be put to terms. Appeal is pending, and undertaking at one point of time was given. So possession taken when the matter was pending, you being an authority, Mr. Dotto, Article 12 authority, you should have approached the court when the appeal was pending. Look, we are taking possession, or do this, direct them to do this. Without that, you have taken possession, and the court exercises discretion and has directed restoration of possession. So if you
Well,
want,
there are
yes.
Well, there are a few things, Milord. Number one, Milord, which I said, Milord, I will be taking as my second point, Milord, the appeal itself is incompetent. Because, Milord, in the appeal was filed out of time, no application was taken out, Milord, for condonation of delay. Therefore, Milord, even if I have given any undertaking which is perpetual in nature, let us assume for argument's sake, Milord, at this stage, whatever is the meaning of the
appeal was time barred.
Yes, it was time barred.
Chatterjee, if the appeal is time barred, then it's difficult. Because there cannot be any dispute on facts, on this factual aspect.
But I've taken instruction when it was filed out of time.
Page 45.
Page 45, yes. এটা এই হচ্ছে কেন, ইকো হচ্ছে কেন, কি ব্যাপার?
When was your
Mr. Dotto? Mr. Dotto, there is some problem from your end, for which there is the echo which is being
But in that case, can I request please take it back tomorrow as the first matter?
No. All right, no problem. Yes, Mr. Chatterjee.
Yes, Mr. Chatterjee.
Milord, at page 45, this is the admission of the appeal.
Milord, before your lordship invites Mr. Chatterjee,
factually,
never a point taken there.
But
Milord, even if I tell you, Lord, if that
Chatterjee,
order stands, Milord, if that order remains unchallenged, if
there is no order saying that, Mr. Chatterjee, if appeal is time barred.
Milord, if this order was, I'm sorry, Milord, just hold it for a minute. This was challenged in High Court. No, this was not challenged. This order remained. What I am saying
maybe,
is,
but if the appeal was time barred, can any order be passed subsequently on that? I am on that because
I ask this question to myself. Good, bad, indifferent, in an appeal, an order has been passed. That order, Milord, is not a nullity. It has been acted upon, and in terms of that, they have taken money.
But Mr.
Milord,
Chatterjee,
that's what they say, that
I appreciate that.
Yes,
but what would be the effect of an orders passed in a time barred appeal without condonation of delay? That's what is troubling me.
I am, Milord, taken for a ride here. Now, he is, Milord, a state. He is Milord, a landlord of Milord absolute integrity. He can't be like a private landlord. He is, Milord, a landlord with he is like a model landlord. That is what the
Mr.
Supreme Court
Chatterjee,
says.
that's
Yes,
one thing. Can you come back on this? Because this you have to, if that is so, you have to text this. What can be done?
My lord, if
That's
it
a
is,
different thing that I
then
will
may
consider.
I ask this question to myself? First two orders, undertaking given, not challenged, accepts money from me. Till my lord, July 2026, they have accepted money from me. Now, this is like my lord, a very surreptitious landlord who accepts something which is going on, which is wrong, and then takes
Can it
advantage
be,
of
Mr. Chatterjee? There are two things.
Yes, ma'am.
If
I bow down to what your lordship is, my lord, observing.
yes,
I
if it
bow,
is,
but kindly
no,
for a
I
second
appreciate
here.
that, but let us take a hypothetical case, not this case. An appeal filed beyond time or a time barred appeal. Now, then it is taken up and orders passed on that.
Kindly comes to
Can
45.
you say, or
No,
can
no,
it
no,
be said?
Kindly comes to 45.
Yes.
Kindly
No,
take it up.
prior to that, I will come to
No.
45.
45. Thereafter.
Yes.
Chup.
Yes. Oh, appeal filed in time.
Appeal filed in time.
No, no, Milord, we have the instructions, Milord. Mr. Nag will, Milord, address your
There is no
lordship as to when
question
Milord the appeal was
whether
filed.
it is wrong. One second.
But Mr. Dotto, only one thing. Mr. Dotto, only one thing. The appeal court records appeal filed in
Yes.
time. So for that, can a party be faulted if the court records wrongly? He also could have taken steps. Mr. Dotto, it frequently
Milord,
happens. An appeal is filed
Yes.
and an application is moved. At that point of time, we
Yes.
get from the stamp reporter's report that the appeal is barred. The appeal may not be, the appellant may not be knowing. So when it is pointed out, then they take out an application or they take steps for that. So here is a case where the appeal records it is appellate.
This is 21st of February.
Milord, may I, Milord, address your lordship on this point?
Yes.
Milord, whether, Milord, it is pointed out to the court or not, Milord, going by the, Milord, principles of Milord, section 3, Milord, though, Milord, it does not apply over there, Milord, it is for the court to satisfy itself whether the point is taken or not. That
No,
limitation
yes.
does not stand in.
Mr. Dotto, there is no quarrel to that proposition. There is no quarrel to that proposition, but here is a case, Mr. Dotto, where the court, it's a case where you may say that yes, limitation not considered. Here it's a specific finding that the appeal filed in time, and based on that finding, both parties act on that. It's not that one of the parties act. Both parties act on that finding. Whether thereafter, at one stage of time, you can take advantage by saying it's a wrong recording.
This is a writ petition.
Milord, I don't say, Milord, let us consider two situations. One situation is, Milord, all the parties, Milord, proceed on the basis that, Milord.
Just give me a minute. Kindly look to the cost title once. Looks to the cost title once.
Civil division.
Yes, have a look at it. What he has prayed for.
What?
What he's prayed or what he's said below in the cost title. Have a look at it. As if this is a writ petition. First of all, appellate side, I'm forgetting about it. Then, so he is now challenging this order. He is actually, my lord, challenging this order.
28th of July.
No, I'm not challenging the order.
28th July.
Milord, my learned friend will kindly, Milord, permit me to address your lordship, Milord, on the point raised by the court.
Entire proceeding is under challenge. So there is no limitation there. So there is no limitation there. So this is a surreptitious thing being done, Milord. After doing something wrong, you can't take advantage of that. And the court.
But I'll address your lordship, who has done the wrong. Well, first thing is, Milord, as I was, Milord, addressing your lordship, Milord, please assume for the time being that, Milord, everything was in order, and later on it is found.
That tomorrow, our replace.
I'll take care of it. Lordship takes it up in the morning.
Morning.
Anytime, your lordship. I have no problem.
Because morning, if it is taken up, motions will be difficult.
Whenever-
Mr. Dotto, tomorrow, if I keep it, because it seems that he will be taking some time.
Sometime, I'll take some time, my lord.
Uh,
Maybe at 2 o'clock, my lord, subject to your lordship's business.
Not 2
permitting.
o'clock. Then from 2 to 4:30, this will continue.
No, I don't think.
So
your
from
lordship will
2 to
take more than 10
4:30,
minutes. I don't think my lord will take more than 10 minutes.
from your submissions, what is happening there?
No, after what Mr. Datta said very nicely, my lord,
Yes.
the gods are also angry.
Yes. So,
My lord, around 3:15 then?
My lord, in the morning, there is no chance.
Morning, Mr.
10
Chatterjee,
minutes, 10 minutes. I don't think more.
not 10 minutes, Mr. Dotto, the way he has started,
No, that
and
is
the
because he was thinking
energy he has stored in himself.
That is because he was thinking he was arguing a writ petition, not a.
Milord, I go by my name. The exuberance still continues. The adolescent exuberance continues.
Milord, both of us were together before your lordship at Jalpaiguri.
Yes.
Back together as well. So we had a conversation about his Kishoratto.
Heard Mr. So here is the tax audit is to be done here.
Tax audit will be October, but that is the GST has to be paid.
No, for that, Mr. Dotto, can it be done if
No,
some?
but I want the entire. I'll make my submissions on the entire property.
No, that if for in the meantime, if you want to some documents you want to bring out from that.
We need the entire property after tomorrow.
All right.
After whatever happens after.
3:30 Friday.
They will want it. Kindly do not do that. I don't have a problem because only records. Milord, only records. The pendency will not be create a stay in executive.
Yes.
Take that to rent.
Yes.
সেগুলো টাকাগুলো নিয়েছিস? হ্যাঁ আমার থেকে প্রবেশ বাহ
Lordship, that 37.
Lordship, item number 37, my lord. I am
37, your lordship.
for the petitioner. My lord, the next date is fixed in February
37
2027, my lord.
37. Next date is
On 16th February 2027, my lord, my written objection is already on the record, my lord.
Yes, I have said 16th of February 2027.
My lord, cannot fix a date earlier to that, my lord, because the
No,
bank.
preponing cannot be done from here.
My lord, from
Or if it caveat দিয়ে দিন,
I have served, my lord.
no,
I have served.
preponing cannot be done. The
Number 34, your lordship was pleased to
34,
my lord. Your lordship was pleased to dismiss it for default, my lord. I was engaged.
dismiss for
Default, my lord.
take out an application for restoration.
New motion, my lord. Kindly.
New motion, there is no provision for restoration. Yes, Mr. Mukherjee, the civil procedure code has been amended. Since when? He is saying new motion restoration application cannot be filed. Department not accepting. Department.
Kindly.
Why you are not here?
Engaged before the division bench, my lord. Kindly.
That happens with busy lawyers. Look at Mr. Mukherjee, he manages all matters, even if he is very busy.
It's my fault.
You
my lord.
cannot manage.
It's my fault, my lord. I could not appear, my lord. Kindly.
Ask Mr. Mukherjee how he manages. ওটাকে 34টাকে
the matter I was arguing yesterday, my lord. Only thing is that tomorrow I may not be available. Only prayer if an adjournment is sought, if your lordship kindly grants a short passover.
Short passover?
Tomorrow, if your lordship kindly.
My lord, I mentioned on Monday, my lord.
You have mentioned on Monday.
And
You have mentioned on Monday.
Monday, my lord, and I am preferring to file a can for an early hearing, my lord. If you give a leave,
That you file an application.
If you give
For that leave is not necessary. You file in the department.
no, if your lordship can keep it for tomorrow, day after tomorrow.
Can you file? It will appear in due course. File can, it will appear in due course.
Yes.